Welcome aboard, applicants. I thought we would continue our PT analysis, part 3, working through the Janice Wright regarding Janice Wright or potential Janice Wright litigation. And now that we've established our structure, we've put in our issues, we have put in our rule. Now we need to fill in our what would represent our writing phase. Now we need to establish at this point our explanation. Well, explanation of what, you might say? Our explanation of the cases that help to establish what our rule was, our rule of standards was, or were, I should say. And this would be for the issue number one would be Brady. So we need to go down and look into Brady right here. Thank you for your patience with me. Right here, because this is Miller and then Brady. Here we go. And within about 2 to 3 sentences or so, establish what it is that happened in the Brady court. Now, this is we read here that Martha Thomas and her son Craig Thomas appealed the judgment in favor of Craig's former personal manager Sharon Brady for unpaid compensation under a contract. Because Craig had a right as a minor to disaffirm the contract, we reverse. Under Brady, the court okay. Reversed, or the court held that Craig or I should say this, under the Brady court, the holding reversed Craig's right as a minor to disaffirm the contract because, and we need to fill that in now. Now, in 1999, Brady entered into an artist manager's contract with Martha and Craig, who was then 10 years old. Martha signed the contract and wrote Craig's name on the signature page where he was designated artist. Craig did not sign the contract. Pursuant to the contract, Brady was to act as Craig's exclusive personal manager in exchange for a commission of 15% of all consideration paid to Craig as an artist during the 3-year term of the contract. Now, in 2001, Craig obtained a recurring acting role on the Acme television network show The Go-Kart Kid some weeks later. Martha sent a certified letter to Brady stating that Craig no longer needed her management services, could no longer afford to pay her a 15% commission because they owed a large amount of taxes, and were thereby terminating the contract. Within days, Brady responded, informing Craig that he was in breach. Now, in 2002, Brady filed suit against Craig for breach of contract. After a bench trial, the court found that Brady had proven her case by a preponderance of the evidence and awarded her a commission of $150,700. In doing so, it rejected Craig's defense that the contract was invalid because, here it is, because Craig was a minor at the time he entered into it. Craig appealed from the ensuing judgment. As a general proposition, potential consent is required for the provision of services to minors. We talked about this. For simple reason that minors may disaffirm their own contracts to acquire such services. Okay, so this is under Brady, the holding reversed Craig's right as a minor to disaffirm the contract because, as the court stated, parental consent is required for the provision of services to minors for the simple reason that minors may disaffirm their own contracts to acquire such services. Now, we went through all the 6701 and 6702 here. So reading further on now. Although in many instances such disaffirmance may work a hardship upon those who deal with a minor, the right to avoid contracts is conferred by law upon a minor for his protection against his own providence and designs of others. It is policy of the law to protect a minor against himself and his indiscretions, and we talked about this further. Any loss occasioned by the disaffirmance of a minor's contract might have been avoided by declining to enter into his contract in the first place. Simply stated, one who provides a minor with services does so at his or her own peril. Now, no specific language is our own risk. I should say, excuse me. No specific language is required to communicate an intent to disaffirm a minor's contract. A minor's contract may be avoided by any act or wording disclosing unequivocal intent to repudiate its binding force and effect. We find that Martha's certified letter was sufficient to constitute a disaffirmance of the contract by Craig because it stated that Martha and Craig were terminating the contract. Therefore, we conclude that. Oh, excuse me. Let me. I'm glad I talked about that. Holding reversed. Okay. Under the Brady Court, the holding reversed the trial court decision that Craig's right as a minor to disaffirm the contract. Craig had a right to disaffirm the contract as a minor disaffirm. Okay, because as the court stated, parental consent is required for. Okay, or this too that. I think that was pretty much it. I think it's good, but we'll use that later down here. Excuse me. Stated a minor's contract may be avoided by any act or word disclosing an unequivocal intent to repudiate its binding force and effect. Okay. What we might do down here is bring this now. Let's see. I don't think. Okay. Yeah. Okay. We'll just. The court argued that parental consent is required for the provision of services to minors for the reason. Okay. Okay. And then now this is the last one. Ultimately, the court concluded that, let's see. Okay. That Craig's disaffirmance was sufficient. Okay. 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 Now we need to establish as to whether is this like or unlike our situation here. I would have to say it's like our situation. Like Brady, Ryan is a minor and has the intent to disaffirm his contract with GamerTracks Okay. First of all, the facts state that, or the element of Ryan being a minor was established by, then we're going to bring this up here. Now we're going to go into our files. Let's go into our file right now. Up here. Thank you for your patience. Okay, up here it says, okay, here it is. Oh, it was established because, okay, here it is. Number one, Ryan is Janice's 12-year-old, and that Ryan, I'm sorry, is 12 years old. Let's put it like that. And number two, this goes down. Now, we want to make sure to point out that this came from the memorandum, the September 29th, 2020 letter. Okay, now number two, and then what we're going to point out is that the contract itself stated that Ryan was under the age of 18. Here it is, right here. Oh, right here. That number two, that the agreement Ryan entered into indicated that, or right, entered into with GamerTracks indicated that he understood that he was under the age of 18. Okay. And then I want to make sure to point out that this came from the same letter. Okay. Now, hence, under both CFC 6701, CFC 6702, and the Brady case, Ryan may disaffirm his contract with GamerTracks. Okay. All right. You know what? We could actually make this as independent sentence here. Now, going to Janice's letter to disaffirm, we want to point out that when, okay, first up here under 6702, what is it here? Okay, in the Miller case, because in the Miller case is going to help establish. Let's see here. Okay, here it is. Here we go. Cut that and bring that up here. Okay. This is what the Miller case helped us to establish, that there was a power to disaffirm that flows from Janus, because Janus, according to the 6702, is the parent of the minor, or guardian of the minor. Power to disaffirm. Minor's power to disaffirm. Okay. Okay, now down here. Okay, there we go. Now, in Miller, let's go to Miller now. Okay. By his complaint, Bryce Miller sought judgment against his mother, Josephine Miller, for $26,000, representing payments issued to him when he was under 18 years of age under a contract of employment as an actor. Bryce now appeals from a judgment in favor of Josephine. Bryce was born on March 11, 1940. In 1953, Bryce entered into a contract with Couch Studios are incorporated to portray a role in a television series. At the same time, Bryce entered into a contract with Josephine, under which she relinquished any right to any money paid to him pursuant to his contract with Couch. Pursuant to this contract, Couch issued to Bryce 30 checks in the aggregate amount of $35,000. Of these, Bryce endorsed and deposited 4 checks in the aggregate amount of $9,000 into his own account. At Bryce's discretion, Couch delivered the remaining 26 checks in the aggregate amount of $26,000 to Josephine. Josephine endorsed Bryce's name in these checks, or on these checks, and deposited them into her own account. Bryce authorized Josephine to use the money to take care of both of us. Now, by this action, Bryce seeks to recover the $26,000 received by Josephine. There can be no doubt that Josephine held this money for Bryce. By her contract with him, she had relinquished any right to any of it. He was entitled to recover all of it, unless Columbia Family Code 6703 stood in the way, which is what we're going to be talking about later. Under that provision, a minor under the care of a parent who is able to provide for him may contract to pay the reasonable value of those things for his support and that of his family, and may not disaffirm such a contract. That being true, it must follow that the minor can authorize the use of money held for him for those purposes and cannot recover the money thus paid out. Now, in entertaining the judgment for Josephine, the trial court found that she expended the $26,000 she had received for herself and for Bryce. That finding, however, was insufficient to support the judgment. The court did not find that Josephine expended the money for herself. Okay, so in Miller, the court found that Josephine had used the $26,000 for herself and for Bryce for things necessary for their support. Now, nor could the court have so found. The evidence showed that at all relevant times, Josephine had an independent and substantial source of income. Also, the court pointed out that Josephine had an independent, substantial source of income. Okay, then it also showed that she expended the $26,000 she had received, as she herself admitted, for the good things. As it had us. Okay, so also the court pointed out that Josephine had an independent, substantial source of income, which substantiated the argument that yeah, that's right. We're pointing this out. We're actually setting up the Miller explanation right now. That oh, she used the funds for the good things of life. Okay. Not necessaries or necessities. Okay, so right there. Here, okay. Here, or I should say this, unlike, or I should say like our case, excuse me, like our case, or excuse me, like Miller, excuse me, like Miller, Ryan used the funds, put the $20 provided to him from his mother to purchase. Oh, is it Miller just about a yeah, exactly. For okay, provided to him from his mother to purchase in-game, and up here the facts up here point out that it was in-game purchases right here. Purchase in-game options such as that enhance their online video gaming experience, such as extra weapons and extra lives. Okay. Janice did not provide. Okay, so I put this in here. Argument could be made that Janice's funds to Ryan were not for necessaries or necessities, but were in fact what Miller calls good things of life. Therefore, gamer tracks may argue that Ryan's in-game purchases were not for, or I should say this, Ryan's in-game purchases that Janice is disaffirming, or attempting to disaffirm, were not for for the, let's see, well, not for, what did it point out here? For things necessary. Oh, I need to point this out too up here. That this came from the September letter. Therefore, GamerTrax may argue that Ryan's in-game purchases that Janice is attempting to disaffirm were not for the things necessary for their support. And this is where it gets really interesting. This is where I'm still learning a whole lot on this. Now I'm not really sure about where to go from here. That's why I think we have a good start on Janice's letter to disaffirm the contract. So I probably want to put a bookmark right here, and I'll come back and fill this in because we got a lot of ground to cover under Janice's liability for the $8,980 charge down here. But I'll put a bookmark right here. We'll come back in part 4 and fill out the rest of this. Okay. Thank you so much for tuning in. I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher. I also want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Again, thank you for tuning in, and God bless.